Presenting before you the legal updates for today live from the Honorable Supreme Court of India. In All India Judges Association and others versus Union of India and others, the Supreme Court examined whether the requirement of 3 years of legal practice in addition to a law degree should be reinstated for candidates appearing in the Civil Judge Junior Division examination. This issue arises in light of challenges faced by high courts regarding judicial officers' lack of exposure to court functioning. The condition was previously removed by the Supreme Court in the All India Judges Association case 2002. A bench comprising Justices B.R. Gavai, A.G. Masih and K.V. Chandran is currently hearing a writ petition filed by the All India Judges Association which raises multiple concerns, including judges' pensions and service conditions. During the deliberations, senior advocate and Amicus Curiae Siddharth Bhatnagar specifically addressed the question of reinstating the 3-year practice requirement. However, following the recommendation of the 1996 Justice K.G. Shetty Commission, which was also known as the First National Judicial Pay Commission, the requirement was abolished by the 2002 judgment of the All India Judges Association. The Shetty Commission observed that the requirement of 3 years of practice deterred young law graduates from joining judicial services. It was suggested that rather than imposing a 3-year waiting period, it would be more beneficial to provide them with training for 1 or 2 years. The Supreme Court deliberated on the necessity of 2 to 3 years of prior legal practice before entering judicial service, with most high courts supporting the requirement for efficient judicial functioning. Justice Gavai noted that earlier unattractive service conditions no longer deterred lawyers from joining the judiciary early. The Amicus presented differing high court views, with Andhra Pradesh and Assam advocating a 2-year minimum practice, while Punjab and Haryana and Uttarakhand supported 3 years of minimum practice, counted post All India Bar examination. In contrast, Sikkim and Chhattisgarh opposed restoring the practice requirement. A key challenge discussed was ensuring genuine legal practice, as many candidates focus on exam preparation without courtroom experience. Justices Masih and Gavai highlighted instances where lawyers had on-paper experience without actual advocacy, emphasizing the need for a reliable certification mechanism by presiding judges to verify practical courtroom engagement. In Safia PM versus the Union of India, the Supreme Court directed the Union to submit its response within 4 weeks in a plea seeking a declaration that individuals born as Muslims but who no longer adhere to the faith should not be governed by Shariat law. A bench comprising Chief Justice of India Sanjeev Khanna and Justices Sanjay Kumar and K.V. Viswanathan was hearing a petition filed by Safia PM. The petitioner sought the application of the Indian Succession Act 1925 instead of the Muslim personal law in matters of inheritance and succession for those who have renounced Islam. During the proceedings, Solicitor General Tushar Mehta, representing the Union, informed the court that the petition raised an interesting question as the petitioner viewed Shariat law as regressive. He further explained that the petitioner, who has only one daughter, wishes to bequeath her entire property to her. However, under Shariat law, she can only bequeath 50% of her estate. Mehta emphasized that the petitioner sought the benefit of the secular Indian Succession Act. In response, the CJI observed that if an exception were created for a non-believer born into one faith, it would have to be extended to non-believers from all religions. He further pointed out that under the Hindu Succession Act, a person who converts out of Hinduism also loses inheritance rights. However, the Solicitor General interjected, clarifying that inheritance through a will remains unaffected by conversion. The CJI, however, noted that this would not apply in cases where the predecessor dies intestate or if joint Hindu family property is involved. Following these discussions, the bench directed the Union to file its counter affidavit within 4 weeks. The Chief Justice of India, Justice Sanjeev Khanna, highlighted 3 key challenges currently facing the Supreme Court of India: the backlog of cases, escalating litigation costs, and the erosion of integrity among lawyers. He addressed these issues during a ceremonial bench session marking the conclusion of the Supreme Court's Diamond Jubilee year. Praising the court's values of accessibility and diversity, Justice Khanna stated, "What distinguishes the Supreme Court on the global stage is its unique character as a genuine people's court." He emphasized the court remains accessible to the common people and in its diversity, the judges in the courtroom and the wide range of voices find representation at the highest levels of our judiciary. The CJI highlighted the Supreme Court's evolution as a living institution, adapting to the changing challenges of each era while staying grounded in constitutional values. He described the first decade as the sunrise years, focusing on building a newly independent nation's constitutional morality with key decisions like Romesh Thapar versus State of Madras and Daryao versus State of Uttar Pradesh. The second decade was marked by the court's interpretation of law under Article 13, culminating in the landmark judgment of the Keswanand Bharti case, which protected the Constitution's basic features from amendment. The third phase, spanning the 1970s to 1980s, emphasized social justice and equality marked by the introduction of public interest litigation or PIL to empower marginalized sections of society. And through many other such cases, the Supreme Court has always strived to win the trust of citizens who have turned up to the apex judicial body with huge hopes. Alright, that was it for today. We hope you liked the video. For more such interesting updates, do keep following us. Till then, stay curious, stay legal.